My daughter was driving a brand new Camry the other day, and she got stopped by the police, and she had her Bluetooth on, and she was talking through her car phone, and the police stopped her, and he seen her iPhone sitting on her car seat, and the iPhone looks just like her cell phone, and she tried to tell him it wasn't her cell phone, it was the iPod, and he gave her a ticket anyway, and he heard her talking through her Bluetooth.
So what is your question?
My question is, what should she do about that?
Well, Francis, she has a right to contest that ticket, and usually she'll be given a court date. The first thing she needs to do is go and appear at that court date, and they'll ask if she pleads guilty or not guilty, and she's not guilty of it. She needs to plead not guilty. Then they will schedule a hearing in which the officer will come in and explain why he gave a ticket, and she can explain why she shouldn't have gotten one, and the judge, or actually you could demand a jury trial if you wanted to, but usually people end up paying those because it's only a $50 fine. But if she's not guilty, I would not advise her just to go pay the fine. I would go on in, contest it, and it sounds like she's got a good case.
Okay. Well, how many distracted driving cases actually go to jury cases?
Most of them are just stay with the judge at a bench trial. That's where most of our cases end up, unless it's something more severe.
Okay. But when you want to fight, you can take it all the way.
You can go all the way. You have that right.
But the penalties get worse and worse each time that you are charged.
Okay.
So that's something mindful. And what is it, 15 points, you lose your license for, is it a year, I think?
That's a year.
One of the questions, though, that we had from the staff here that were posed to us while we were on break, and that question was, if you're involved in an accident or if you're pulled over, does the officer have the right to go into your phone to see if you were talking on it?
No. They do not. It has to be an extenuating circumstance for that to happen. The Supreme Court has already ruled that would violate their Fourth Amendment if we just go pick their phone up and take it. Now, if they give us permission, we can ask. If they want, if they say, yeah, here, look at it, that's different. But we can't just go, give me your phone, I'm going to look at it. Now, we can get a warrant and go before a judge, get a warrant if it's something severe, like let's say a fatal crash. They're going to go get a warrant for that phone and look and see if that's what was going on, because they're going to do a full investigation.
And I presume if it's a fatality involved, they're going to be charged with vehicle homicide.
Possibly, depends on what happens and the circumstances around it. So, but just a minor rear ender, we go up to them and ask them, hey, were you on the phone? They say no. If we don't have any suspicion that might have happened, that's the end of it. If we think they are, we may talk to them. If a witness says, hey, they were on the phone, we may ask them more questions, do a little more digging, but we're not just going to take your phone and just start looking at it.